Hello and welcome to Daily News Simplified, an answer to what, why, and how of newspaper reading from UPSC Civil Services examination perspective. Today we are going to take important news appearing in the New Delhi edition of the Hindu newspaper dated 1st December 2022. Now today is Thursday and it's time for DNS Weekly Mains Practice question. So the question for this week is, what is the role of Law Commission of India? How far has its recommendations shaped the legal and judicial ecosystem in India? Explain with suitable examples. Now before attempting this question, you can go through the DNS of 13th November 2022 discussed by Faizan sir. Now let's start our discussion with this news appearing in the editorial section on page number 6. And this news is with respect to the ongoing conflict between executive and judiciary, particularly with respect to the mode of judicial appointment, which is presently done through the collegium system. Now, yesterday, Ankit sir discussed in detail about various reasons with respect to pendency of cases in the courts. And the appointment process was just one of the reasons for pendency. However, in today's discussion and in this article, it focuses on a totally different thing, that is the primacy, which means who has primacy with respect to judicial appointments to higher courts, that is appointment of judges of High Court and Supreme Court. So the question remains that who has the primacy? Whether is it the executive, because ultimately they are appointed by the president, or is it the collegium system, because in the present circumstances it is the collegium system which forwards the proposal, which is then followed by the executive through appointment by the president. And this is the crux of today's discussion as to who has or who enjoys primacy with respect to judicial appointments. Now, the Government of India, through the Constitution 99th Amendment, enacted the National Judicial Appointment Commission Act of 2014. However, this particular act, along with Constitution 99th Amendment, was declared unconstitutional by the Supreme Court. And based on this particular question was asked in the mains of 2017. The question was, critically examine the Supreme Court judgment on National Judicial Appointment Commissions Act 2014 with reference to appointment of judges of higher judiciary in India. Thus, this aspect of judicial appointments to higher judiciary has always been a crux of debate between the executive and the judiciary, particularly with respect to enjoying primacy over such appointments. And if you look at the syllabus of GS paper 2, then you see that it provides for salient features of the Indian Constitution, amendments of the Constitution, significant provisions, and also basic structure. This topic also gets covered under the subheading of separation of powers and also structure, organization and functioning of executive and the judiciary. Now, so far what has happened is that the collegium has recommended certain names for judicial appointment. However, the government delayed the appointments and as of now has returned back the file. Now, according to the Supreme Court judgment in the third judge's case, the system of appointment of judges of High Court and Supreme Court through the collegium system is final, and the judiciary enjoys primacy as declared in the second and third judge's case. And the fourth judge's case effectively declared Constitution 99th Amendment along with NJC Act as unconstitutional, thereby reviving the collegium system of appointment. And now the executive seems to revive the debate by calling that the collegium system of appointment is alien to the Constitution of India and is also opaque in its functioning. Whereas on the other hand, the judiciary has reiterated that the system of appointment of judges through collegium is final according to the Supreme Court judges, and the executive should not force it to give judicial pronouncement on the same. So this whole issue of primacy of executive or judiciary with respect to judicial appointments has again become alive. And in this regard, let's understand as to why the Supreme Court declared the Constitution 99th Amendment Act along with NJC Act as unconstitutional, and also provision of Article 124 Clause 2 with respect to appointment of judges of Supreme Court, both after Constitution 99th Amendment and prior to Constitution 99th Amendment. So this is the constitutional provision with respect to appointment of judges of Supreme Court prior to Constitution 99th Amendment, that is prior to enactment of NJC Act. So it stated that every judge of the Supreme Court shall be appointed by the President by warrant under his hand and seal after consultation with such of the judges of Supreme Court and of the High Courts in the states as President may deem necessary. Whereas Article 124 Clause 2 after Constitution 99th Amendment states that every judge of the Supreme Court shall be appointed by the President by warrant under his hand and seal on the recommendation of National Judicial Appointment Commission referred to in Article 124A. So it is the third point where the provision varies. As you can see that prior to Constitution 99th Amendment, the third point reads that judges shall be appointed by the President after consultation with such judges of the Supreme Court. So the matter on which the issue of primacy rested was the provision of consultation under Article 124 Clause 2. And the question was whether this consultation is binding or this consultation is mere advisory. And finally, in the second judge's cases, the Supreme Court declared that government or the executive does not enjoy primacy with respect to consultation process. And the system of collegium emerged in the third judge's case. So the second judge's case in the year 1993 declared that referring to the consultative process provided under Article 124 Clause 2, the court stated that the government does not enjoy primacy or absolute discretion in matters of appointment of judges of Supreme Court. The court also said that provision for consultation with Chief Justice was introduced as the Chief Justice of India is best equipped to know and assess the worth and suitability of a candidate, and it was also necessary to eliminate political influence. So again, the issue of executive interference and also political interference was mentioned here. The court further stated that selection should be made as a result of participatory consultative process where executive has the power to act as a mere check on the exercise of power by CJI to achieve constitutional purpose of judicial appointments. However, the Supreme Court held that initiation of the proposal for appointment of Supreme Court judge must be made by the Chief Justice of India. And ultimately, the third judge's case in 1999 led to the emergence of the collegium system, where the Supreme Court in a presidential reference under Article 143 stated that while making recommendations, CJI shall consult 4 senior-most judges of Supreme Court, and this overall led to the emergence of the present collegium system. The court also held that opinion of all members of the collegium regarding their recommendation shall be in writing. The views of the senior-most Supreme Court judge, who hails from the High Court from where the person recommends comes, must be obtained in writing for collegium's consideration. If majority of the collegium is against the appointment of a particular person, that person shall not be appointed. And even if 2 of the judges have reservation against appointment of a particular judge, then CJI would not press for such appointment. So a democratic process was envisaged through the collegium system, and a High Court judge of outstanding merit can be appointed as Supreme Court judge regardless of his standing in the seniority list. Now this is where the problem arises, as there are no specific guidelines to highlight as to what are the criteria to select such outstanding meritorious candidates. So whatever names are suggested by the Collegium of Supreme Court with respect to either appointment of judges of Supreme Court or appointment of judges of High Court or their transfer, it must be followed by the executive, and executive has no other choice. Now the government, in order to override this provision of consultation under Article 124 Clause 2, which was followed through the process of collegium system, enacted the National Judicial Appointments Commission Act of 2014 along with Constitution 99th Amendment. However, it was declared unconstitutional by the Constitution Bench of Supreme Court, stating that it violates the basic structure of judicial independence and also interference by the executive. Now, if you look at the composition of NJAC, which was added in the Constitution through Constitution 99th Amendment, it stated that there shall be a commission to be known as NJAC, comprising of the Chief Justice of India as the chairperson ex officio, 2 senior judges of Supreme Court next to Chief Justice of India as members ex officio, the Union Minister in charge of Law and Justice as member ex officio, and 2 eminent persons to be nominated by the committee comprising the Prime Minister, Chief Justice of India, and Leader of Opposition in Lok Sabha. So the Supreme Court stated that the presence of Union Law Minister amounted to interference in judicial independence, and it also violated the provision of Article 50 of the Indian Constitution, which provides for separation of judiciary from the executive in public services. So the question as to why was NJAC Act along with Constitution 99th Amendment declared unconstitutional, the first reason provided by the Supreme Court was that it violated basic structure doctrine. And the 5-judge Constitution bench declared that Constitution 99th Amendment along with NJAC Act as unconstitutional as it violated the basic structure of the Indian Constitution with respect to judicial independence as provided under Article 50 of the Indian Constitution, and it also amounted to interference by the executive in judicial appointments. The next reason was inclusion of members of executive. So it stated that Constitution 99th Amendment introduced Article 124A, which provided for the composition of NJAC, which apart from members of judiciary also included Union Law Minister and Justice and 2 eminent persons to be appointed by the central government. And this overall violated the independence of judiciary. And here the Supreme Court held that Article 124A was insufficient to preserve the primacy of the judiciary in matters of selection and appointment of judges to the higher judiciary, as the inclusion of members from executive not only violated the principle of independence of judiciary but also violated the provision of separation of powers. And accordingly, subclause A to D of Article 124A was set aside or declared unconstitutional by the Constitution bench of the Supreme Court. And this particular judgment of the Supreme Court effectively revived the collegium system. And the Supreme Court stated that since NJAC Act was violative of the basic structure of the Constitution, hence the current appointment process through the collegium system will continue. So it's important to understand here the meaning of judicial independence and as to what comprises judicial independence and the constitutional provisions which ensures judicial independence. Now the first point highlighted regarding judicial independence is separation of power as provided under Article 50 of the Constitution of India. Now, Article 50 states that the state shall take steps to separate the judiciary from the executive in the public services of the state. So this is the provision regarding separation of judiciary from the executive, and this forms part of directive principles of state policy under Part 4 of the Indian Constitution. The next constitutional provision which ensures judicial supremacy is security of tenure of judges and their removal as provided under Article 124 Clause 4. So Article 124 Clause 4 states that a judge of the Supreme Court shall not be removed from his office except by an order of the President passed after an address by each house of the Parliament supported by a majority of total membership of that house and by a majority of not less than 2/3 of the member of that house present and voting. So judge of a Supreme Court and also that of a High Court cannot be removed arbitrarily by the executive. The third point is that the Judges Inquiry Act 1968 provides for a complete procedure for the removal of judges of Supreme Court and also High Court. The next provision which ensures judicial independence is Article 125 Clause 2, as it says that salary of judges cannot be reduced. And the next constitutional provision is that expense of the Supreme Court shall be charged upon the Consolidated Fund of India as per Article 146 Clause 3. Now this means that the expense of the Supreme Court shall not be subject to voting in the Parliament. So Article 146 Clause 3 says that administrative expenses of the Supreme Court, including all salaries, allowances and pensions payable to or in respect of the officers and servants of the court, shall be charged upon the Consolidated Fund of India, and any fees or other monies taken by the court shall form part of that fund. The next constitutional provision is that the jurisdiction of courts cannot be diminished. The next constitutional provision is regarding Article 121, as it insulates judges from criticism in Parliament and state legislature. So it says that no discussion shall take place in Parliament with respect to the conduct of any judge of Supreme Court or of a High Court in the discharge of his duties, except upon a motion for presenting an address to the President praying for the removal of the Supreme Court or High Court judge. So this constitutional provision also protects the judges of High Court and Supreme Court from contempt proceedings being initiated against their judicial functions. And the next point, although not provided explicitly in the Constitution, but based on Supreme Court judgment, we can say that freedom of interference from executive in appointment through the collegium process. So these can be said to be some of the constitutional provisions and also other legal provisions with respect to judicial independence. Now let's also go through the merits and demerits of the functioning of collegium system. Although this topic has been discussed by Jatin sir in the previous DNS, however, let's revise the merits and demerits of the collegium system. The first point provided is that it ensures independence of judiciary as mandated in Article 50 from interference of the executive. The second provision is that views of the judges of High Court and Supreme Court are taken down in writing, and the prevalence of majority opinion favors democratic process of appointment. And in case two judges express their reservations against appointment of a particular person, then the collegium halts the appointment process or does not take forward the appointment process in case of doubtful candidates. And such a system also allows talented lawyers from the bar to be appointed as judges of High Court or Supreme Court directly based on their performance. But this provision also becomes one of the demerit because there is no specific guidelines as to which lawyer shall be recommended for judicial appointments, as generally those persons are considered who have a strong judicial background or a strong lawyerly background. So talking about the demerits of collegium system, obviously there is lack of transparency and accountability in the appointment process, as we can say that judges appoint judges. The second demerit is lack of any method or reasons, as such reasons are not provided in case of transfer or promotion of judges. So the criteria are not very clear with respect to transfer or promotion of judges. And this leads to the next demerit, which is lack of specific guidelines to select senior lawyers for appointment as judges of Supreme Court or High Court. Further, lack of consensus among members of collegium results in delay or even reversal of decision at times. The next demerit is nepotism, as we have already seen, as accusation of favoritism and preferential treatment to members from judicial fraternity. Now, another demerit of the collegium system can be said to be politicization of judiciary, as lack of transparency or any criteria in selection of judges for appointment could lead to politically motivated appointments, and lack of a permanent commission comprising members from diverse backgrounds. So even the Law Commission in its 121st report proposed to set up the NJSC for appointment of judges. And even National Commission to Review the Working of the Constitution in its 2002 report highlighted the need for National Judicial Commission for the purpose of appointments to higher judiciary. So these can be said to be some of the merits and demerits of the collegium system. Now, as of now, the confrontation between the executive and judiciary is increasing day by day. So let's wait and watch as to what happens with respect to the collegium system of appointment, or whether the government introduces a new version of National Judicial Appointment Commission Act. Now, based on our discussion, this becomes your practice question for mains. The question is, critically evaluate the evolution and functioning of collegium system for appointment of judges, and this question carries 15 marks. So this issue of hostility between judiciary and executive needs to de-escalate or needs to calm down, and both sides needs to work in a collaborative manner, as government should not stall the process of judicial appointments, and also the judiciary should look forward to reform the collegium system of judicial appointments. Thus this article becomes important both from the perspective of prelims and mains examination under GS paper 2. Now let's take up this editorial appearing on page number 6, and this editorial is with respect to outsourcing of electoral work or election work to private agencies such as NGOs or civil society organization. Now this particular news highlights about the decision of Bruhat Bengaluru Mahanagar Palika. The Bengaluru Municipal Corporation has cancelled the permit which it had provided to an NGO to carry on house-to-house survey in order to improve voters' awareness. Now it was alleged that this NGO, in the garb of improving voters' awareness, was collecting details of the voters including their voter ID cards, their Aadhaar card, without any legal authority or without approval from the state government. And the members of the NGO also deceived the voters by saying that they were working for the Bangalore Municipal Corporation. And this deception allowed the NGO to collect their voter identification details such as voter ID card or EPIC card along with Aadhaar. Now the problem here is that the electoral laws, namely the Representation of People Act and also state laws, are silent with respect to outsourcing of electoral works to private agencies. And the data collected by such NGOs or private entities such as Aadhaar, phone number, voter ID could be easily harvested both by political parties and also by corporates. And this may lead to misuse of such important personal data of citizens. Now, the concern with respect to collecting these metadata is that it can lead to exclusion principle by targeting certain castes or certain communities. And this can also lead to profiling of voters. Further, collecting these data without proper consent of the voters also impacts right to privacy under Article 21 of the Indian Constitution. And because of this, the Bengaluru Municipal Corporation must ensure that whatever data were collected should be immediately deleted and legal action should be taken against the NGO. So this editorial highlights certain concerns with respect to collection of such important data, particularly the voter data, especially by NGOs who are not allowed or who are not legally entitled to collect such data. The first concern highlighted is with respect to the absence of data protection law, and the second concern highlighted is regarding the linking of Aadhaar with electoral data. Now, the government has introduced Election Laws Amendment Act of 2021 last year, and this law allows the electoral registration officer to use Aadhaar card to verify authenticity of the voter. And this has been done by amending certain provisions of Representation of People Act 1950 and also 1951. And this law also provides for linking of Aadhaar with voter ID. So on this note, let's go through some of the merits and also concerns or demerits with respect to linking of Aadhaar with voter ID. Now, one of the major reasons as to why this step has been taken is to avoid duplicity and curb the menace of multiple enrollment of same person in different places. Further, it will also improve accessibility of voting. It will improve voter participation, especially for migrant workers. It will also make it easier for new voters as it provides for 4 qualifying dates within a year instead of just 1 qualifying date which was earlier. And this makes authentication easier for government authorities because of linking of voter ID with Aadhaar. Now, having said this, there are still certain concerns which needs to be addressed. So the concerns highlighted is that in absence of data protection law, such integration can undermine integrity of electoral roll. Now, another set of concern is that linking of voter ID with Aadhaar can lead to possible disenfranchisement. Now, how this will happen? Suppose if a person has more than one voter ID card, and in the process of linking of Aadhaar with voter ID card, it shows multiple entry. And there is a possibility that because of this multiple entry, the linking does not go through and it leads to the deleting of voter ID of such person. However, it is to be noted that disenfranchisement of lakhs of voters happened in Telangana in the year 2015. And also so far, according to the Election Laws Amendment Act of 2021, linking of Aadhaar with voter ID is not mandatory. So it says that linking of voter ID with Aadhaar can lead to possible disenfranchisement, and this may impact the constitutional right to vote of the Indian voter under Article 326 of the Indian Constitution. So the Election Commission must ensure that linking of voter ID with Aadhaar does not lead to mass disenfranchisement. Now, collection of such details or such demographic information by the government may be used for targeted advertising or possible deletion from electoral rolls. And given the reported scope of fraud with Aadhaar, this process could undermine the sanctity of voter roll. Next, linking of Aadhaar must also pass the triple test of right to privacy with respect to legality, need, and proportionality. So the law approving linking of voter ID and Aadhaar must have a legal base, there must be a specific need for this purpose, and the law must be proportional. Now, another set of concern is that voter ID is issued only to citizens of India, whereas Aadhaar is issued to residents of India. So there is a possibility that synchronization or linking of Aadhaar with voter ID may allow voting rights to non-citizens, as Aadhaar is issued only to residents, whereas voter ID is issued only to citizens. So these are some of the concerns with respect to linking of voter ID with Aadhaar. Thus, this article becomes important from the perspective of polity and governance and gets covered under GS Paper 2 with respect to appointment to various constitutional posts, functions and responsibilities of various constitutional bodies, in this case the State Election Commission and also the Election Commission, and salient features of Representation of People Act. Now let's take up this article appearing on page number 6, and this article highlights about the importance of micronutrient malnutrition. So we must understand what are micronutrients and what leads to malnutrition or undernutrition with respect to consuming these micronutrients. Now, according to CDC, that is Center for Disease Control of United States, micronutrients, often referred to as vitamins and minerals, are vitals to healthy development, disease prevention, and also well-being of a human being. And with the exception of vitamin D, micronutrients are not produced in the body and must be derived from the food diet. And since micronutrients have to be derived from food diet, hence there is a need for food fortification, which is basically adding micronutrients to our staple diet such as rice or wheat. So it says that food fortification is a proven cost-effective and complementary strategy to address India's malnutrition problem. Now, according to the Global Hunger Index of 2022, it has put India in the serious category. And according to this report, the children in India suffers from acute malnutrition. Now, there are 4 important aspects with respect to malnutrition. These are undernutrition, that is share of population with insufficient caloric intake, child stunting, which is an impact of malnutrition, which means share of children under the 5 years of age who have low height for their age. That is, they're not growing according to their age. And this also reflects chronic undernutrition, which means the child are not given proper nutrition in their developing age. The next point is child wasting. Now this refers to those children under the age of 5 years who have low weight for their height. And this also reflects acute undernutrition. And other instances, child mortality. Now because of undernutrition, it results in death of children below the age of 5 years. So it says share of children who die before their 5th birthday, partly reflecting fatal mix of inadequate nutrition and unhealthy environment. Now this topic of Global Hunger Index and its various aspects pertaining to malnutrition was covered in the DNS dated 15th October 2022. Now this article also highlights about the Global Hunger Index and other indices to highlight the problem of malnutrition in India. And this article says that according to the National Family Health Survey 5 data, every second Indian woman is anemic, which is a condition in which the body does not have enough healthy red blood cells. Every 3rd child is stunted and malnourished, and every 5th child is wasted. So with respect to acute malnutrition in India, this article suggests that food fortification is a good step forward, and various countries across the world have also framed laws with respect to food fortification. Now, before understanding the importance, impact, and various government schemes for food fortification, let us understand about the important role played by micronutrients. And according to Center for Disease Control and Prevention, these are the 6 important micronutrients which are also fortified in various food diets. So these 6 important micronutrients are iron, vitamin A, vitamin D, iodine, folate, which includes vitamin B9 and also B12, and also zinc. So let's go through some of the important highlights with respect to these micronutrients, as it will help us to understand that why food fortification is important to address the issue of malnutrition, not only in India but across the world. So it says that iron is critical for motor and cognitive development. Now cognitive development means the development of thinking ability of children. So it says children and pregnant women are especially vulnerable to the consequences of iron deficiency. Iron deficiency is a leading cause of anemia, which is defined as low hemoglobin concentration or having less red blood cells. Anemia affects roughly 40% of children younger than 5 years of age and 30% of pregnant women globally. Anemia during pregnancy increases the risk of death for the mother and also low birth weight for the infant. And iron deficiency is a major public health concern because it is responsible for 3.6% of disability adjusted life years or DALYs, which is years of life lost due to premature mortality and years lived with disability. And this is according to the World Health Organization. Now talking about vitamin A, it supports healthy eyesight and immune system functions. and children with vitamin A deficiency face increased risk of blindness and death from infections such as measles and diarrhea. So it's important to address vitamin A shortage by providing supplements to children below the age of 5 years. Now, vitamin D is the only vitamin which is produced internally in our body, and this builds strong bones by helping the body to absorb calcium. Further, it also helps protect older adults from osteoporosis, that is, weakening of the bones. And deficiency of vitamin D causes bone diseases such as rickets in children and osteomalacia, that is, softening of the bones in adults. And of late, it has been witnessed, especially in urban areas, that most of the people have vitamin D deficiency. Now, another important function of vitamin D is that it helps immune system resist bacteria and viruses. So it is also important for our immunity. And vitamin D is required for muscle and nerve functions as well. Now, iodine is important to make thyroid hormones, and these hormones control body's metabolism and many other important functions. So the body needs thyroid hormones for proper bone and brain development during pregnancy and also during infancy, that is, when a child is growing. So having enough iodine is important for everyone, especially infants and women who are pregnant. And fortifying salt with iodine has been a successful intervention for the last 40-50 years, as about 86% of households worldwide consume iodized salt. Now, another micronutrient is folate. And folate, basically vitamin B9, helps to make new cells in the body every day. And folate is essential in the earliest days of fetal growth, as it is important for the growth and development of DNA and other genetic material, and also for healthy development of the brain and spine. Now, folic acid is another form of vitamin B9, and fortifying foods with folic acid as additional supplements reduces the incidence of neural tube defects and neonatal deaths as well. Now, talking about zinc, zinc promotes immune function and also helps people resist infectious diseases including diarrhea, pneumonia and malaria, and zinc is also needed for healthy pregnancies. Further, zinc supplements reduces incidence of premature birth, decreases childhood diarrhea, and also reduces respiratory infections, lowers number of deaths from all causes, and increases growth and weight gain among infants and young children. So providing zinc supplement to children below 5 years is a very highly cost-effective intervention in low and middle income countries. So malnutrition can be addressed by fortifying our foods by adding these important micronutrients in our daily diets. And that is why staple diets such as rice and wheat are fortified with iron, folic acid, and even vitamin B12 to address deficiencies. And it is one of the steps which has also been adopted by the government to address micronutrient deficiency, in addition to provide dietary diversification and also micronutrient supplementation. Now, the Food Safety and Standards Authority of India has notified the Food Safety and Standards Fortification of Foods Regulation 2018. Now, this specifies standards for fortification of staple foods such as wheat, rice and maida with iron, folic acid and vitamin B12. Salt is fortified with iron and iodine, and oil and milk is fortified with vitamin A and vitamin D. However, there are certain health risks which are also involved with respect to the fortification of foods. And because of these health risks, it's important to add these micronutrients in a balanced way. And because of this, the Food Safety and Standards Fortification of Food Regulation provides for or specifies minimum and maximum levels of micronutrients which can be added to these staples. Now, the Government of India is also providing the supplementary nutrition of micronutrients, and it is provided under the Anganwadi Services Scheme in order to bridge the gap between recommended dietary allowances and average dietary intake. So providing these supplementary nutrition not only addresses the issue of malnutrition, but also improves the presence of micronutrients in the body. So it says that supplementary nutrition is provided in the form of hot cooked meal, morning snack and micronutrient fortified food or energy dense food as take home ration. Now, even the states and UTs have been advised to use these fortified foods under the supplementary nutrition program. Now, talking about the benefits of providing fortified diets, it has become a global phenomena, and seeing the health benefits of fortified foods, most countries across the world have framed laws for fortification of cereal flour, fortification of iodized salt, and also fortification of rice. Now, this news further mentions that according to a pilot project which was implemented for fortified rice in Maharashtra's Gadchiroli district, this has witnessed a success in terms of preventing cases of anemia, and that has reduced from close to 60% to 29.5%, that too within a short span of 2 years. Now, the government is also distributing these fortified staple diets through the public distribution system, ICDS, that is Integrated Child Development Scheme, PM Poshan, or the Midday Meal Scheme, and other state nutrition programs. Now, generally, rice is chosen as the staple diet for fortification because 65% of India's population consume rice, and distribution of fortified rice through public safety nets like PDS scheme, ICDS, PM Poshan, which earlier was Midday Meal Scheme, has helped to reduce micronutrient deficiencies among children. And here even state governments have started their own schemes such as Noon Meal Scheme in Gujarat, which also provide micronutrient fortified rice through the Midday Meal Scheme. So providing fortified rice in Gujarat through the scheme found that there was increased hemoglobin concentration, that is increased red blood cell concentration, and it also reduced anemia by 10%. So it says 10% reduction in anemia prevalence, and it also improved average cognitive score as well for the children. So these are some of the benefits with respect to providing fortified diets. However, there are certain health concerns which should not be ignored. And based on the health concern, fortification should take place according to the Food Safety and Standards Fortification of Foods Regulation of 2018, which provides that these micronutrients should be added in a specific range in the staple diets. Now, based on our discussion, this becomes your practice question for mains. So the question is, what is the meaning of micronutrient malnutrition? What steps have been taken by the Government of India to address the issue of micronutrient malnutrition? And this question carries 10 marks. I hope after our discussion, you will be able to attempt this particular question. Now look into this prelims question asked by UPSC in the prelims of 2014. The question was, consider the following pairs, vitamins and deficiency. So options are vitamin C, scurvy, vitamin D, rickets, vitamin E, night blindness. Now, if you look at the discussion on vitamin A, then you find that the aspect of blindness has been associated with vitamin A and rickets is associated with vitamin D. So the question here was, which of the pairs given above are correctly matched? So clearly we can rule out option 3 as vitamin E is not a reason for night blindness. So the correct answer here becomes A, that is 1 and 2 only. Thus, this article on micronutrient malnutrition becomes important, and this topic gets covered under GS paper 2, especially with respect to issues relating to poverty and hunger under social justice. With this, let's take up the next article for discussion. Now let's take up this news appearing on page number 12 with respect to protection of Great Indian Bustard. So this news says that Supreme Court seeks centre's response on evolving a program to protect Great Indian Bustard. Now the population of Great Indian Bustard has been declining, and because of this, Supreme Court in a petition has sought government's response regarding coming up with a conservation program such as Project Great Indian Bustard on the likes of Project Tiger. Now the Great Indian Bustard is considered one of the largest flying birds in the world. However, its population has been continuously on a decline also in India. Now look into this question asked by UPSC in the prelims of 2012. The question was, which one of the following groups of animals belong to the category of endangered species? So in 2012, Great Indian Bustard was endangered. Obviously, the correct answer here was A. However, in the present circumstances, it has been categorized as critically endangered. So one of the major reasons for the decline in population of Great Indian Bustard is loss of habitat due to increase in population, agriculture, and also infrastructural developments taking place across the country. And laying down of electricity transmission wire has been one of the major reasons for the death of Great Indian Bustard. So it says that these birds are large and usually take low flights, which often result in deaths due to collision with electricity transmission lines. And even stray dogs attack the bustard's egg and their young ones. So this is one of the major reasons for decline in their population. Regarding their distribution, they were formerly widespread across both India and Pakistan. However, in the present time, its population is estimated to be less than 200 across Rajasthan, Gujarat, Maharashtra, Madhya Pradesh, Karnataka, and Andhra Pradesh. So, as of now, it is very rarely found in the Kutch area of Gujarat, Solapur and Chandrapur area of Maharashtra, Kurnool area in Andhra Pradesh, Bellary in Karnataka, and in pockets of Rajasthan, mainly concentrated near the Desert National Park of Rajasthan. Now let's go through some of the important highlights with respect to Great Indian Bustards. So these bustards are extremely endangered group of birds dependent on grassland ecosystem. Now there are 4 species of bustards in India. These are Great Indian Bustard, Lesser Florican, Bengal Florican, and Howbara Bustard. And these are among the most threatened of the 22 bustards found in the world. Now, Great Indian Bustard is now locally extinct from almost 90% of its former range, and that's why, according to IUCN, it has been categorized as critically endangered. Now, during the 13th Conference of Parties to Conventions on Conservation of Migratory Species of Wild Animals, which concluded in India in Gandhinagar, it listed a total of 10 migratory species of the world on its Appendix 1 and 2 of the convention, along with adoption of number of resolution. Now, important point to be noted here is that 3 of the species have been listed from India during the 13th Conference of Parties to the Convention on Conservation of Migratory Species of Wild Animals. And the 3 Indian species are Great Indian Bustard, Mainland Asian Elephant, and Bengal Florican. Now, regarding their conservation status, they are listed as critically endangered category of IUCN Red List, listed in Schedule 1 of Indian Wildlife Protection Act of 1972. It is also listed in Appendix 1 of CITES. It has been identified for Species Recovery Program under Integrated Development of Wildlife Habitat Scheme, and it has been declared as the state bird of Rajasthan. Now, protected areas of Great Indian Bustard in India include: in Rajasthan, the Desert National Park close to Jaisalmer and Barmer; in Gujarat, the Nalia Sanctuary in Kutch; in Madhya Pradesh, the Karera Wildlife Sanctuary; in Maharashtra, Nannaj Grasslands and Solapur; and in Andhra Pradesh, Rollapadu Wildlife Sanctuary. So these are some of the important highlights with respect to the Great Indian Bustard, whose population is on a decline in India. And because of this, the Supreme Court has sought response from the government regarding their conservation. Now, this topic becomes important mainly from the perspective of your prelims examination under the section of environment. With this, we come to an end to today's discussion. Thank you for watching DNS. And if you like our effort, then please like our videos, subscribe to our channel, and also press the bell icon to never miss any video lessons from Rao's IAS Study Circle.